you had a good Passover for my Jewish friends. Now, man, we've got a lot to talk about, but I want to dig in here. A lot of violence out there. I mean, really hideous stuff going on. But before we get to that, let's get to this. Judges. The administration has taken the position that no federal judge can order a president of the United States to demand from another country that they take their citizen who's been deported to their country and bring them back to the United States. The administration has also argued that a judge does not have the power to interfere with foreign policy like that either. The administration is correct 100%. Now, I like to go back to the beginning, as you know, ladies and gentlemen, the beginning being the Constitutional Convention, sometimes before that. And this issue actually came up. You know, we didn't always have a Supreme Court and a president and separation of powers. They sat down in Philadelphia over that summer for a little over 5 months, and they worked out the details of this fantastic governing document, the Constitution. The world has never seen anything like our Constitution, then and since. And so they were creating this office of the presidency. They were creating this Supreme Court. They were doing something that had never been done before. 3 separate branches of government, the judicial, the legislative, and the executive. It had been mentioned a couple hundred years earlier by Montesquieu in his writings. It was mentioned a little bit earlier than that by John Locke in his writings, but Montesquieu was very specific about what he had in mind. And they weren't the only ones. Divided power. Aristotle wrote about it. Cicero wrote about it. And if you look at England, once the monarchy began to lose power, they had a separate parliament and a monarch and a court system. At no time, not one syllable was expressed in support of the idea in any of the state ratification conventions that received the Constitution that the judiciary was lacking power, that this Supreme Court that they created was lacking power. But what's interesting, and I did a little review of this over the weekend, if you go back and you look at Madison's notes and you look at what they proposed about the presidency of the United States, they did have an idea that came up and was quickly rejected by the overwhelming majority of the delegates at the Constitutional Convention, and that was a judicial council. And this judicial council, as they were thinking about it, would oversee every decision that would be made by this president they were thinking of establishing. And so you would effectively have some kind of judiciary, some kind of court, some kind of judges having the power to veto a presidential decision or to help convince a president to change his decision, somehow, alter it or modify it. Now, 3 of the most powerful of the delegates who came up with this idea, 2 of them being Madison himself and John Dickinson, supported it. But the vast majority said no way. This president that we're thinking of establishing, this executive branch, there must be a distinction between the judges and the president and these members of the legislature. There must be a distinction. There must be a separation of powers. Because Montesquieu, as they would later write, informed them that if the legislative becomes part of the executive, or the executive becomes part of the judicial, or judicial becomes part of the executive, you will have tyranny. That's what he said. Now we bring it to modern day. We have a phalanx of judges unknown to you. Their resumes unknown to you. Their backgrounds unknown to you. Without your consent, without your knowledge, without your input in any way. Determining that they shall make executive branch decisions. That they will, in fact, be a judicial council, if you will. Looking over the shoulder of the president. Making decisions for the president, in lieu of the president. Or trying to force the president to modify his decisions. And they do this without any constitutional basis whatsoever than an interpretation of the Constitution which was wholly bastardized back in 1803 under Marbury versus Madison by a very partisan political Chief Justice by the name of John Marshall. That's the only basis upon which they're doing what they're doing. It completely changed the nature of our government. One of the great constitutional thinkers of all time was not a lawyer, but he was a historian / philosopher, and his name was Raoul Berger. And Raoul Berger wrote an entire book on this subject, and he was prolific in the books that he wrote and prolific in the research that he did, like few others. He and Robert Bork became good friends. But he was a professor. He became a professor. He didn't start out that way. He was an immigrant, a Jewish immigrant from Germany. And he talked about government by the judiciary. He did the most thorough analysis of this of anybody I've ever seen. He's not with us any longer, unfortunately, but you understand. And there is nothing that confers this kind of power on these courts. The lower, appellate, or Supreme Court for that matter. Nothing. They talk about the necessary and proper clause. Folks, you're going into second-year law school here with me, but I'm putting it in plain English. The necessary and proper clause. What's that all about? Well, the clause isn't actually called the necessary and proper clause, but it is a clause in the Constitution where Congress is granted the power to pass laws and the executive to enforce laws that are necessary and proper for what? For the general welfare of the public? No. For what? The more modern activists call this the elastic clause. The elastic clause. And so, you see, their perspective is the necessary and proper clause destroys the entire Constitutional Convention, the focus of the Constitutional Convention, the construct of the Constitution, the Federalist Papers, everything, just with this one clause, the necessary and proper clause, that somehow authorizes Congress to do whatever necessary and proper that Congress thinks is necessary and proper. So here you have two views from the hard left that are preposterous. One is that the judiciary, through judicial review that's not in the Constitution, power seized by the Marshall Court, embraced and expanded by subsequent courts, judicial review, we have the final say. Where's that written? Nowhere. And then that Congress can pass laws on anything it wants if it's necessary and proper. Necessary and proper meant what? It meant when Congress passes a law within the construct of the Constitution that has to do with national matters or has to do with the language that is specific to Congress under Article 1, that otherwise the states pass laws. The state create the bank, not the Fed, not the national bank that the Washington created and so forth. Now the states have all this authority. The lawmaking was released to be the province of the states. But with the necessary and proper clause, argue the big government types, basically Congress can pass laws on anything they want. And under the Supremacy Clause, whatever Congress says goes, whether the states like it or not. That is not what was debated and discussed at the Constitutional Convention. Nothing even like it. What the necessary and proper clause meant then and should mean today. If Congress passes a law legitimately within its Article 1 powers, defined authority, that it can pass additional laws that are necessary and proper for carrying out the laws that were properly passed in the first place. Or that the executive can take steps to execute laws that were properly passed under Article 1 in the first place. It didn't give Congress the power to pass laws on everything it wants. Necessary and proper. Oh, great. You with me on this, Mr. Producer? It gets a little heavy, but this is where we need to be. So we have a situation where the Supreme Court seized power from the other branches of government and says, we will say what is final, period. They call it implied powers. Implied powers can mean any power. Implied powers has no boundaries. What does that mean? That's number one. That's the court. Number two, Congress has seized power from the states that Congress does not have. The necessary and proper clause doesn't give it to Congress in any respect. Number three, the Supremacy Clause. What the federal government passes, the Congress passes is supreme to anything the state passes. No. It means if there's a conflict of laws, that is, where Congress is operating within its Article 1 powers and it passes a law that is legitimate under the Constitution, and let's say it conflicts with a state or several states' laws, under those circumstances and those circumstances only, does the Supremacy Clause kick in and Congress wins the dispute. The federal government was to be very limited in what it could do. But what it could do, it had very powerful authority. But it had to operate within its zones, within its lanes. I know this is heavy. I've thrown concepts to you. I've thrown the Constitution at you. I've thrown what they've done to the Constitution at you. But it's very important to understand, implied power, judicial power, does not exist. The necessary and proper clause, which they claim allows Congress to pass laws on anything they want, that's not the necessary and proper clause in the Constitution. The Supremacy Clause, of whatever the federal government does, trumps the states. That's not what the Supremacy Clause means either. So you can see the centralization of power under the federal government. And this is what Donald Trump, whether they articulated at the Justice Department this way or not, it doesn't really matter. This is what they're trying to challenge and confront. The problem is the Supreme Court has given itself the power to make the final decision. And the lower courts have given to themselves the power to make the initial decision and usurp the power of the presidency.